Hello, everybody, and welcome to Macro Pro and Friends webinar series, our 12 Days of Christmas. We are on our 10th CEU right now. I'm joined by Jim Umholtz from law firms of SCHLOSSBERG and Umholtz. Is that correct?
SCHLOSSBERG and Umholtz, correct.
Excellent, excellent. How are you doing, Jim?
I'm very good.
I think I forgot to introduce myself. For those that don't know me, I'm Diane Cohen with Macro Pro. And I do host these events, and they're always so much fun to have people like Jim on board. So Jim, tell me, what are you doing for the holidays?
Well, I'm getting together with family. I'm cooking a few small dishes myself, but my sister does most of the cooking. And we just get together and relax comfortably.
Now, we thought of a question to ask our audience. So why don't you, it was a great question you came up with. Why don't you answer them? And then I'm going to go ahead and see who's replying. Thank you, Emily. Emily loves our antlers.
It's always a discussion in my family whether we're going to have dinner buffet style or whether we're going to have a sit down dinner. Now, some people like the convenience of the buffet. Some people like the sit down, the presentation, the formality of it. And that's the question I have for the audience today: is what is the better method, sit down or buffet?
Oh, you want a better method, or what are they doing this year?
Yeah, well, let's know what they're doing, because that will kind of give us an idea of what they prefer.
Yes, exactly. Well, we see here Diana's already said buffet. Chuck has said buffet. Kevin has said Christmas tapas. Oh, I like that. We've got, they prefer to sit down dinner, Renee. A sit down, Roberta. Unwrapping tamales, says Martha. Buffet from Sandra. Ravi is also, and then Chinese food from Andrew. So, I wonder if he's a good, like my husband's family, a nice Jewish family that does Chinese food on Christmas every year. We have Lisa, who's also doing a buffet. So I cook a big primary dinner every single year for my family. I do all of the fixings. Nobody can bring anything, and we do a buffet style, just because I can't plate that nice. I'm not Gordon Ramsay. I don't have plating skills, so can't do that. So thank you, everybody.
In and of itself.
Yes, exactly. So thank you, everybody, for sharing your thoughts on buffet or sit down. Adriana's just said sit down. All right, so for 12 CEUs, we've got the first, you will be receiving your certificates in approximately 1 hour. We are finding people's firewalls are taking a very long time to get through during the holiday season. The longest I've heard is 4 days. So if you don't see it immediately, don't freak out, but do check with your IT department, because it's usually a firewall issue. If you have any questions for Jim, put them in the question box, just where you were putting in your answers. In the background, we have a little angel, Logan, and she's going to be monitoring the questions and asking Jim those questions as they arise, and if we can fit them in appropriately. And then if you have not done so already, please download the handouts. Jim's put together a beautiful set of handouts. You're definitely going to want to have the information. And then this presentation will be available on the Macro Pro YouTube channel first thing tomorrow morning. So Jim, with that, have a fabulous webinar.
Thank you very much. I do want to thank you, because it's always a pleasure for me to be invited and to participate in the Macro Pro Friends webinar series. It's a great pleasure for me, and let me see if I can operate the equipment correctly here. Today we're going to talk about, let me get the reopening files. Now, this is not something that we commonly see, but it does happen with any file that is settled by stipulation with a request for reward. But as I begin, I want you to know that the subtitle to this program is The Subtle Beauty of the Compromise and Release. Now, I want you to write that down, because I want somebody to ask me later in the presentation why the subtitle is The Subtle Beauty of the Compromise and Release. I put my usual disclaimer here. Basically, this is for educational purposes. If you need guidance on a specific file, you need to talk to your attorney directly. You can reference the material I've given here, but make sure you get specific facts in for specific advice. Now, I like to do presentations differently, and this one I'm going to begin at the end. In other words, the end of the claim. How did it end? because by far the most common closing for most claims is administrative closure. In other words, we get a claim in, we accept liability, we provide benefits, the employee goes back to work, and now the claim is closing. So, hey, we're done with the claim, right? Well, what I strongly encourage you to do is remember in your notice letters to include Reynolds language. Now, what is Reynolds language? That's language in the letter that tells people that if they fail to act timely, they may lose their right to benefits. If we fail to include Reynolds language in our benefit notice letters, we get to the point where the statute of limitations does not toll and their rights continue forever. So we want to make sure that when we close these files, the ones that aren't litigated, the ones that people return to work, and maybe they only have medical treatment or maybe they only have nominal permanent disability, that we give them proper notice. I've given you the website at the bottom here so you can make sure that you can check your notices, but make sure they include some type of Reynolds language in your closing notices. Let me see what we've got here. Now, what is a statute of limitations? I know most of you know this already, so I'm not going to belabor the point, but it's simply a statutory time limit for somebody to act, and there's usually requirements relating to that statutory time limit. If we fail to meet our time limits, if we fail to give the proper notices, that statute of limitations never begins to run. But remember, that statute of limitations is an affirmative defense, and if we do not raise it, especially regarding jurisdiction, we waive it. We're going to talk more about this as we progress. Labor Code, the two sections I'm going to be discussing regarding statute of limitations are 5410, which addresses both original jurisdiction and continuing jurisdiction. But Labor Code section 5410 gives an employee up to 5 years to file an application. Now, as you're aware, the application for adjudication of claim is the document which establishes the jurisdiction of the appeals board. And when it is filed, it establishes original jurisdiction. We will get on to the purpose of the seminar, though, is continuing jurisdiction. But I want to point out to you Labor Code section 5405 because that creates 3 different bases for filing the application for adjudication. The first is the date of injury. There's 1 year from the date of injury. We all know that. The second is 1 year from last payment of indemnity benefits. The third is 1 year from last payment of medical treatment. Now, my point in telling you this is we can have one of those administratively closed files that reopens for medical treatment 4, 5, 10 years down the road. And once we provide that medical treatment, they have a year to file an application, regardless of Labor Code section 5410. So remember, these are not absolutes. This is a floating number. If we provide the treatment, they can file an application and establish original jurisdiction.
Hey, Jim.
Yes.
I just wanted to check. I'm new to this this whole platform, but I see a hand up from Sharon Hansen. Do you have a question? No? Okay, maybe it was an accident. Just wanted to check.
No problem. I encourage questions. I've asked Ms. Logan to ask me the questions if you put them into the chat. If you need to reach out to me quicker, let me know. Now, we've talked about the non-litigated claims. How do the litigated claims end? Well, we look for the compromise and release because that resolves everything. Otherwise, we look for the stipulations with request for award where we reach agreement to all of the important relevant issues. Then, of course, there's the findings in award or the findings in order, and that's allowing the judge to make the determination. Now, I'll tell you from personal experience, if I can settle via stipulations where myself and applicant attorney control the terms of the settlement, I would much rather do that than simply proceed to trial and let the judge determine everything. Compromise and release, as you know, brings everything to a conclusion. Now, once the award or order issues, what do? Well, we pay, or we follow the requirements of that order. But you're going to see in my presentation that I put a few practice notes because I want you to be cognizant of these issues as we're going forward, as you're handling claims. So for example, with the CNR, the CNR form itself includes 30 days to pay language. In other words, the applicant, by signing the CNR, is waiving penalties and interest for 30 days. but no such language is included in a stipulations with request for award, and it's certainly not included in a findings award, so that there is no grace payment for payment. If you're paying a findings and award or a stipulations with request for award more than a day or so after, you do have to consider interest, and make sure you remember to commute the attorney fee if that's part of your agreement in the stipulations. Also, as a practice note, if you're preparing the stipulations with request for award, include include language that waives payment of penalties and interest for up to 30 days if you can reach agreement to that, so that you don't have to worry about that grace period. You don't have to worry about interest or penalties in the days after you get that award. But it is included in the CNR already. The stipulations, it is not. So what happens after you paid your award? Well, the board has continuing jurisdiction even if nobody does anything. You will see that they have jurisdiction to enforce the award under Labor Code Section 5803. We'll talk about that in a moment. But with the filing of a petition, they can reopen the claim either for good cause under Labor Code Section 5804 or for new and further benefits. We're going to talk about each of these as we move forward. Just remember that for reopening the claim for good cause or new and further benefits, a petition should be filed. Now, I mentioned jurisdiction several times. I want to make sure we understand each other. Jurisdiction is simply the authority to hear and determine an issue. And as you know, the Workers' Compensation Appeals Board has exclusive jurisdiction over injuries arising in employment. But that jurisdiction takes different forms. Original jurisdiction is the jurisdiction that they have between the filing of the application and whatever settlement we do. That's original jurisdiction. Continuing jurisdiction occurs after the award or order. Now you say, well, Jim, what's the difference? Well, there's limits on what can be addressed through continuing jurisdiction. That's the purpose of today's discussion. Now here's a practice note. In workers' compensation, the board addresses issues. In civil litigation, in criminal litigation, generally they try and address all the issues at one time. For example, in a criminal proceeding, issues that aren't, in a civil proceeding, issues that aren't raised timely are simply waived. But in workers' compensation, they can address TD without addressing any other issues. They can address entitlement to a QME issue at trial without addressing any other issues. And once that issue is addressed, it transfers from original jurisdiction to continuing jurisdiction. So under the old laws where there wasn't a 5-year limit on temporary disability, if TD was litigated early on, they now have a limited period to invoke continuing jurisdiction if they want temporary disability later. It's less relevant regarding TD now because the law limits us to a 5-year period for payment. But in the older days, knowing that issue jurisdiction was important kept applicant from relitigating some issues in a non-timely way. As part of this issue jurisdiction, I want to remind you that when you enter into a settlement by a compromise and release or stipulations with request for award, you want to make sure that every body part alleged in the claim is addressed. I'm not saying you need to include it in the stipulations as a body part for future medical treatment, but you want to make sure that it is addressed somewhere in the form. You want to look to the claim form, the employer's first report, the application, deposition testimony, or even medical reports to see if body parts are alleged, and then specifically include them in your compromise and release or put them in the stipulations with request for award as dismissed with prejudice. Any body part that has not been addressed in your settlement document remains under original jurisdiction and can be litigated into the future. You want to close those doors when you have the opportunity. Likewise, if you're preparing a pretrial conference statement, you want to make sure that every body part is listed. Now, I'm not sure if everyone is aware, but when you go to trial for a priority conference to address AOE, COE, that litigation doesn't necessarily address body parts. So if the board finds that applicant did in fact suffer an injury at a priority conference trial, let's say to their back, that doesn't limit the litigation only to the applicant's back. That simply establishes AOE, COE, and now they can address other body parts. We don't want that to happen voluntarily, or we don't want to stimulate that on our own. So when we fill out a pretrial conference statement, we want to make sure that the body parts are either listed as sustained or as claims to have sustained, so that the judge can address each one of them at a normal trial, and then make sure that every body part is closed. I'll come back to visit that later, you'll see. So let's talk about continuing jurisdiction. Under Labor Code Section 5803, the board has jurisdiction forever to enforce awards that they have issued. And that, you can see from the language here, they have the power to review, grant, regrant, diminish, increase, terminate, blah, blah, blah. Understand that this is all done without a petition. So they can go and revisit treatment. They can revisit body parts that weren't dismissed with prejudice to determine if treatment is necessary. Now you say, Jim, what would this lead to? Well, it can be under treatment of original body parts. It can be for a compensable consequence injury. It can be treatment for a body part that's not listed in the settlement or in the pretrial conference statement. But be aware that may remain under original jurisdiction. An applicant may have the opportunity to try that unnamed body part sometime in the future. But understand, this ability to enforce its awards is not limited to 5 years. This goes on and on and on. The board has said that it is not time barred at all. And I'm telling you this because in enforcing the awards, the Labor Code, Section 5814.5, provides that applicant attorneys can be paid for enforcing payment of compensation awarded. And I give you an example of the Becerra case, where after litigation, the applicant attorney was awarded $6,320 to overturn an untimely UR decision and get his client physical therapy and an MRI. Now, I don't know about you, but I would hate paying an applicant attorney $6,300 to get services that the applicant is probably entitled to anyway. And if we know that utilization review is untimely, it's probably not in our best choice to secure it. I doubt the physical therapy, the MRI, and the nerve conduction study totaled $6,000 once it was completed. But because of the litigation, applicant attorney was paid to do that. That's 5803 and 5814.5, giving applicant attorney a windfall. Now, continuing jurisdiction can also be for good cause. That's Labor Code Section 5804. Now, what you really need to know about good cause is that it is intended to address inequitable awards. If there was some type of mistake made along the process, then that is the purpose of 5804. That's the good cause. And any party in interest can file a petition to change the award, and that's to rescind, to alter, to amend. Usually you hear somebody say through mutual mistake. But you'll see here that there are times when the award itself was simply inequitable under the facts. In the Benavides case, the parties entered into a stipulations with request for award at 51% permanent disability before the final AME report issued. The AME had not seen nerve conduction studies in EMG that was done before the stipulations, but a review of the EMG was not done until after the stipulations. And after the EMG, the disability increased to 72%. And in that case, the board said that it was wrong for the parties to enter into the stipulations before the final report had issued, that the applicant was entitled to additional permanent disability, not for new and further disability, but because good cause demonstrated that this should have been the original disability. The original award was inequitable because it did not address all of applicant's disability. When you think about good cause, think about 5804. When you think about 5804, think about good cause. The other way to invoke continuing jurisdiction is for new and further disability. Now, Like many things in workers' compensation, new and further is not defined in the labor code or in statutory law. But what the Supreme Court has said is that it must be a demonstrable change in the applicant's condition, and it must be a demonstrable change in a disability that the employer has previously provided benefits. In other words, it is less likely to include an additional body part not previously treated, but rather maybe a compensable consequence body part or a further disability to an existing body part. And I give you the common examples of recurrence of temporary disability, an increase in permanent disability, a new need for medical treatment, maybe a medical treatment that wasn't anticipated previously. But these are the three primary ways in which continuing jurisdiction exists under the Workers' Compensation Appeals Board, and two require petitions, 5410 and 5804. I give you a brief summary on the 20th slide here, which just goes over who may do this, what we're looking for, what types of outcomes we're trying to remedy. Was it an inequitable result, or is it something new? We're going to dig a little bit more into each of them just a moment. Now, there are some rules that apply pretty much to both petitions. These petitions, they are similar in nature, for example, the 5-year time frame, but they have some differences. So, for example, under Labor Code Section 5804, under the Good Cause section, it is not necessary that the change in disability occur within 5 years, only that the petition be filed within 5 years. So for good cause, it's not necessary that the disability change in 5 years. Under Labor Code Section 5410, the disability must occur within 5 years. Now, why am I telling you this? If you see a petition to reopen come in, under what code section, under what legal theory was it filed? If it was filed under good cause, 5804, then we have to look for, did the disability occur within 5 years? If it's filed under 5410, new and further, same question, but it must be limited to the 5 years. If it is filed under both, then the door's wide open for disability to occur. You want to look at the theory behind it. Neither petition to reopen can be used to relitigate issues which weren't addressed at trials or weren't addressed on petition for reconsideration. So if they're simply trying to relitigate an issue they've already lost, that is not, they cannot do that. But once the petition to reopen is filed, it has the effect of throwing the entire case open for review. Now, I put that language in quotes because it was actually included in a discussion in a case in September of this year, that Bundy versus County of San Luis Obispo. The board reiterated that once a petition to reopen has filed, the entire case is now open for litigation. What does that mean? That means that despite your stipulations with request for award, despite the findings in award, if a timely petition to reopen has been filed, we are back to square one in terms of litigating that case. It is just as though the application for adjudication has been filed. We have to address all the issues that we would normally address. Maybe we're talking about average weekly wage. Maybe we're talking about the diminished future earning capacity. Maybe we're talking about benefits paid. All issues are open for relitigation once the petition to reopen has been filed. Now, with that in mind, applicant doesn't have to request that all disabilities be addressed. Once the continuing jurisdiction is established, the board can rule on any issue presented to them for litigation, just as it can once the application is filed. Now, if you've already been to a QME, if you've already been to a AME, and that medical legal evaluator still exists, the board strongly encourages the parties to return to that medical legal evaluator to determine whether there is a demonstrable change in the applicant's condition. In other words, whether there is new and further disability. If that medical legal evaluator no longer exists or is no longer available, certainly you can use a different provider, but the board strongly encourages that.
Hey, Jim.
Yes.
Okay, I think we also have a raised hand from Tracy. Do you have a question? No. Okay. Tracy, if you end up having a question, you can type it and I can read it out. I just see her hand was up, so just wanted to ask. Thank you.
By the way, for everyone listening, you'll see at the bottom I cite various cases which relate to the topic above it. At the back of the presentation, I provide a comprehensive list of all these cases, their citations, and a brief synopsis. Had I included that within the presentation, it would take far longer to communicate to you. Let's keep going. The board has determined, by the way, that the 5-year statute of limitations is an affirmative defense. And if we do not raise it, we waive it. So in other words, if applicant files their petition to reopen 6 years after the date of injury, and we do not challenge that, we waive it. So we want to make sure that we check the dates and we raise all defenses available. Unfortunately, we cannot petition to dismiss a petition to reopen. We can answer it, we can object to it, but we cannot dismiss it. The court has determined that's equivalent to a motion for summary judgment, and it's not allowed. We can be sanctioned for doing that. So don't try to dismiss a petition to reopen, but there is no evidence required to file a petition to reopen, but there's evidence to proceed to trial. So what I strongly recommend is once that petition to reopen comes in, if you do not have evidence to support it, try and get to trial quickly. Now, the judge may give them an opportunity to get evidence, but then you will address that evidence. You do not want these cases to linger. And I'm going to give, this is story time for me. I apologize to you. It's not in the presentation here, but I inherited a file from another law firm where an employee had received a 3% disability to a knee and had filed a timely petition to reopen within 5 years. And that claim was ignored for a decade and a half, nearly a little over 15 years when it got to my desk. And when it got to my desk, applicant was asking for total knee replacement on that 3% knee, as well as a compensable consequence to the opposite knee. Now, I don't know about any of you, but 15 years ago, I was in different physical condition, much better physical condition than I am now. Time has its way of wearing on our bodies. Had this petition to reopen been addressed shortly after it was filed, applicant would not have required a total knee replacement. Applicant would not have asked for permanent disability for that total knee replacement nearly 20 years after the original injury. Don't let these linger. Once you see them, get them to trial as quickly as you can. Now, you say 5 years from what, Jim? Well, generally it's 5 years from the date of injury. It's pretty simple, right? Now, I'm telling you this, I put this slide in here because when I mentioned earlier about original jurisdiction, if an issue is not addressed, original jurisdiction, it remains under original jurisdiction. So they can address that through the regular trial process. But once the issue has been addressed by the board and award is issued, then they have 5 years from the date of injury to invoke the continuing jurisdiction by filing a petition. Now, when I was new to claims, people were telling me, oh, they can do this within 1 year of a stipulated award, no matter when that happens. That is not true. Sometimes it may be to our advantage if we're right at the 5-year mark to wait till we've passed the 5 years before entering into the stipulation with request for award, because they are barred from filing a petition to reopen for new and further. I'm not so sure about good cause, but I believe it also impacts good cause. So it may be to our advantage to wait if we're right close to that 5-year mark, but assuming we're not, understand that just because we've entered into a stipulated award doesn't extend the period for which they can file a petition to reopen. Let's keep going. Is a petition necessary? Well, I'll tell you what the statutes say, or as I put up here, the statutes. Someone should read this stuff. They say that a petition must be filed setting forth the facts specifically and in detail. Code section 10534 for good cause, section 10536 for new and further. But what does the case law say? Neither specificity or detail is required. All that is required is a timely notice, a timely writing, and notice to the defendant. And if you look at some of these documents down here, a doctor's letter requesting increased disability, a letter requesting an advisory ready, even a declaration of readiness to proceed, which notes that the disability has increased, may serve as a petition to reopen. That doesn't mean we're not going to object to it. That doesn't mean that we're not going to argue that it's untimely. But understand that case law is against us in terms of what is a petition. So does it have to, can a skeletal petition be acceptable? Well, it says that since no petition is actually required, skeletal petitions are acceptable. And you will see down below, I've even given you the cases because it so upset me. No facts are needed under the Blanchard decision. They can simply say applicant has suffered new and further disability. That's all they need to file. No proof of increased disability. They don't need a medical report. They need nothing. They don't have to demand a particular benefit. All they have to do is place us on notice that they're asking for increased disability and that notice be timely. And that's where I give you a little practice note. Just because the case law says that we don't have to have specific details, that doesn't mean our answer can't address that issue. If they're relying on a DOR that's filed, is it timely? We want to make sure that we raise in our answer any defenses available. Because remember, a petition to reopen or the timeframes for petition to reopen are affirmative defenses. If we don't raise it, we waive it. And once we've done this, once we put all the parties on notice that we're objecting to the petition to reopen because there's no information, now we've set the basis for us filing a declaration of readiness to proceed and litigating it. Now you say, well, Jim, what if they show up at the MSC with a medical report saying there's new and further disability? Well, that sounds like a basis to go off calendar for us to address that medical report. And if that medical report hasn't been reviewed by a QME or AME, specifically the one we used previously, that gives us another reason to get further discovery. But if they don't have some type of evidence by the time we get to MSC, how long should this matter linger? This is one of those truly important times for us to promptly litigate the claim, because failure to do so can be quite costly for the employers. I give you a couple cases here. I threw these in because I didn't want to make separate, well, I did make a separate page, but failure to state the correct EAMS case number or WCAB number is not a basis to deny applicant. And you can see that they amended their claim in the second case, the Fisher case, to include a second claim when the injuries were combined to cause permanent disability. In other words, simple mechanical errors may not bar a petition to reopen. The board is extremely, extremely liberal in providing benefits under a petition to reopen, just as they are under the normal case in chief. Now let's talk about temporary disability. When I started in the industry many, many years ago, there was no limits on temporary disability. So the whole issue about litigating a temporary disability issue and reopening that issue became quite relevant, because an applicant could in fact get temporary disability more than 5 years after the date of injury. That's not the case now. Now statutory law, specifically Labor Code Section 4656, limits applicant to receive for present injuries 104 weeks within 5 years of the date of injury. And it's even more restrictive under the rules immediately preceding us from April 19, 2004 through the end of 2007. And that was 104 weeks within 2 years of first voluntary payment. Now I put in there voluntary payment because case law came back to say that if EDD pays while we're refusing to pay TD, we can't count EDD benefits. But under the present law, it says that aggregate benefits are counted in that 104-week period. So when we're thinking about whether or not TD is payable within that 5 years, we have to ask ourselves, what's the date of injury, what rule does it fall under, and are the aggregate benefits totaling 104 weeks yet? And I give you a few examples here on the next page, because if it's a modern injury and we paid 44 weeks of benefits and there's no award, there'd probably be no question as to whether or not we're going to pay additional temporary disability within 5 years. Certainly, we were not going to argue about that. We're going to say, hey, we still owe up to 104 weeks, that's 60 weeks. So if medical documentation supports payment of TD, let's go ahead and payment. What if there was an award under that same 2000 or post 2008 date of injury in which we paid 44 weeks of temporary disability? Well, why is that different? Are we going to demand they file a petition to reopen simply to collect the additional temporary disability, which we'd probably have to pay if we didn't already have an award? So in those cases, I would recommend that we actually provide the temporary disability, even if there's already been an award addressing TD. As long as some of that 104 weeks is still available, why not just provide it to the applicant if it's supported by the medical evidence? More importantly, if we demand that that petition to reopen be filed, that throws the entire case open for review. So we may have to revisit permanent disability. We may have to revisit average weekly wage. We may have to revisit diminished future earning capacity if we force them to file the petition to reopen. Now, what about a post 2008 date of injury with 44 weeks and there's a demand made more than 5 years after the date of injury? Whether or not a petition to reopen has been filed, we are not obligated to pay temporary disability more than 5 years after the date of injury for post 2008 dates of injury. I'll say that again. Whether or not a petition is filed, whether or not an award is issued, after 5 years, we no longer have an obligation to pay temporary disability for dates of injury on or after 1/1/2008. What about the period before that? Well, I'm going to hope that you have no claims in which there's still an issue of TD from a claim predating 2008. But in the event that you've never paid any TD, there is no 5-year limit on the period from 4/1904 to 12/31/07. So if you have paid TD, once TD is paid, you don't have that 104-week limit unless you paid continuously through the 2 years following your voluntary payment. So if you voluntarily paid TD and a demand is made 2 years later for additional TD, you don't have to pay it. But if no demand has been made, if no TD has been paid, doesn't matter where we are now. All that matters is that we have not paid it and we're going to owe something. But remember that if EDD paid while we were denying benefits, then that is not counted in the 104 weeks, nor is it counted towards the 2 years after first voluntary payment. Now, why are most petitions to reopen filed? Well, by far the majority of them that I've experienced.
Hey, Jim.
Dude.
Looks like we have a question. Could a medical report indicating disability be construed as a petition?
There is case law saying that a medical report that indicates increased disability. Now remember, that's increased disability over what was previously awarded, either by stipulations with request for award or findings in award. So in many of the cases that I handle, I will have more than one medical report. Oftentimes I will have a treating doctor's report and I will have a QME's report, and they do not necessarily agree on the level of disability. So if
she wanted to add that she's talking about TD.
About TD?
Correct.
If medical evidence, if we have a post-2008 date of injury and medical evidence indicates that they're entitled to more TD after we've discontinued payment for some reason, maybe they returned to work, maybe they were P&S, yes, they can be entitled to more temporary disability, but I would not rely on a medical report saying they're entitled to temporary disability once again to serve as a petition to reopen. I would argue, if they claim that more than 5 years afterwards that was a petition to reopen, I would argue against that, because that's merely evidence that a temporary disability has recurred, not that it's necessarily increased or is further. Does that make sense? So if the medical report says they need further temporary disability, that's a recurrence of temporary disability, not a demonstrable change indicating an increase. Hoping that answers your question. If not, type something else in and I'll keep going. But what you should know about permanent disability increases is that if the evidence shows a permanent disability increase, the apportionment rules under SB 899 apply only to the increase in disability, not to the original disability. In other words, we cannot claim new and further disability because the apportionment law is now more liberal than it was before SB 899. We can only apply the new apportionment rules to the increased disability, not to the original disability which we had entered into and received an award for. And with that in mind, we're entitled to the credit for the dollars paid under the previous award, but we can't simply subtract the prior award from any new disability. In other words, in the example I gave earlier where the disability increased from 51% to 72%, we can't say, oh, the difference is only 21% and that's what you're entitled to. They get the full 72%, although we do get credit for the dollars paid under the original 51%. Now, under case law, under Labor Code Section 5804, there need not be a causal connection to the original injury to establish compensability for the new condition, as long as it is demonstrated that there was good cause for it. But under Labor Code Section 5410, there must be a causal connection to the original injury. You see why it's important when you get that petition to reopen to establish the statutory basis for which it was filed. Was it simply new and further, 5410, or was it for good cause, 5804? 5410, the case law is much more restrictive. And with some exceptions, payment of any award for this new and further disability begins with the evidence of the existence of the new and further disability and may not relate back. Now, I will tell you there's some case law saying that if it's a permanent total disability award, it relates back to when applicant originally stopped working, stopped receiving temporary disability. I'm not going to go into the distinctions as to which applies. Just remember there's different case law, which impacts permanent total disability. And for our purposes, if it's not permanent total disability, understand that the award dates back to the first evidence of new and further disability, not to the original award.
We have another question.
Good.
What if a decrease in PD impairment is found? Will we be able to take credit?
Keep that question in mind. That is by far the best question I've heard while giving these presentations. And keep that one in mind. We're going to address that topic in just a few moments. What about adding body parts to a petition to reopen? Well, I've mentioned that there must be a causal connection under 5410. There need be no causal connection under 5804. I have mentioned that if you've failed to address that body part in any of your pleadings, it may remain under original jurisdiction, so they can litigate it separately. If you have addressed that body part and is dismissed without prejudice, dismissed with prejudice, no longer can address it. But if it's dismissed without prejudice, it may give the board the opportunity to open up and address that body part at a later date. So you need to know what section or what code section the petition to reopen is filed, and you need to know why they're claiming this body part relates to the injury. It still must relate to the injury in some fashion. So compensable consequence is probably the most common, like the example I gave where one knee needed a replacement and they were claiming the other knee was injured because of a compensable consequence. That is very common. If there is a logical nexus or good cause linking that body part to the original injury, then they may be entitled to treatment and further disability if the petition was timely filed. Now, it gets a little bit confusing when there's a question as to whether the body part was known at the time of the original trial or settlement. So if the body part was known and not addressed, it may be under original jurisdiction. The board may argue that if it was not addressed, that's good cause to reopen and address it. Under 5404, the board has said that the relationship to the existing injuries are not needed when the injury to a new body part develops during the statutory period but manifests later. That's really a liberal standard. So look to the facts of the case. Ask yourself, is there some link that can be applied? But I'm going to give you some examples of, I should go with this before I get there. The petition to reopen may be denied where the applicant knew or should have known about the body part, but did not include it. Well, wait a minute. If we know about it and don't include it, it may continue original jurisdiction. Did applicant know or should have known? Well, I will tell you that through my experience, knowing about a body part is very difficult to prove. The board generally requires that knowledge to an injured employee can only come from a physician. And if the physician doesn't tell them, hey, this relates to your injury, the employee has no knowledge, legal knowledge. There is case law saying that their training experience that may have an impact, but I can tell you from personal experience that a person working in the medical field has no knowledge until the doctor actually tells them that their condition is related. I actually lost a recon on that issue. So don't rely on this knew or should have known standard. It's a very complicated issue as to whether or not the body part should be added. So it's very fact intensive. But understand, look first to the code section in which the petition to reopen was filed, then look to the argument as to why a body part not previously addressed is now being addressed. If it's filed under 5410 and there's no causal connection, we should prevail. If it's filed under 5804, no causal connection is required, so you may want to take a different litigation approach. I've given you a series of cases here that I want you to take a look at. For example, in the Ferragamo case, this was, I believe, another CTE case, a chronic traumatic encephalopathy. But the board specifically said liability for unknown or unknowable injuries cannot be settled. So even if the injury occurred during the exact same period through the same cause and effect as the original cumulative trauma injury, if the medical condition was unknown or unknowable, it can't be settled. You could look at the City of Los Angeles case that dealt with a hepatitis C, for which this case actually settled, there wasn't a test, a diagnostic test to identify hepatitis C, and this person could not be diagnosed with it when he settled his original case. So when he was later diagnosed with hepatitis C and it related back to his employment, they found that it was compensable for the same basic reason, that it was unknowable at the time he settled his original case.
Hey, Jim.
Yes.
We have another question in the chat.
Shoot.
If a new and further is filed because there is increased impairment, when does the applicant prove this? Should they have a medical already? Or what if we go to the QME and there is no increase? Does that mean there is no new and further?
Excellent question. And you hit upon the topic which I'm trying to encourage upon you, and that is prompt litigation. No, absolutely no facts or evidence is required to file the petition to reopen, but facts and evidence are required for trial. If we can get to trial quickly and they have no medical report showing new and further disability, we can possibly obtain a findings and order saying there is no new and further disability. If we go back to the original QME or AME and that doctor says there is no new and further disability, let's get it to trial. Let's get that findings and order saying, guess what? There is no new and further disability, therefore we have to shut this one down. If we do not get to trial promptly and they go back several years later, say 15, and the QME says, yeah, they're worse now, we may have to pay additional disability. So prompt litigation is the key here. And all the rules of litigation apply to petitions to reopen just as it does to the original case. Look here on these cases. Malignant peritoneal mesothelioma was different than the original lung and respiratory asbestosis that applicants suffered. They said this is a different disease resulting from the same exposure. So it was unknowable at the time they originally settled their lung case, so their subsequent case was compensable. More importantly, let's look at this Morales case down here. They had a cumulative trauma injury which had body parts, and they had a specific injury which had some overlapping body parts, one of which was internal. And they did not list internal on the compromise and release for the specific injury. I believe I have my facts right there. Might be reversed. They might not have listed it on the CT. But the bottom line here is, by not listing it, that left it open for further litigation. So once the order approving issued, the applicant attorney filed a new claim for the internal complaints not addressed in the CNR. So I want to encourage you, make sure that everything is addressed in your pleadings. Everything is addressed so that we can close down the case once and for all.
And Jim, we have another question.
Good.
Why do you think petitions to reopen are not litigated promptly? This seems to be a very common problem in the industry as a whole.
That's very simple. We don't give them the same status that we give prior claims. They're usually, the petition to reopen comes in and the file is now with a future medical adjuster or someone who doesn't know the potential costs of the claim. And they just say, well, there's nothing pending, so I've got this petition to reopen. There's nothing in a petition to reopen that places it on calendar. There's nothing in a petition to reopen that really highlights for defendants that this can be a time bomb waiting to go off. It's interesting that you should ask that, because in another presentation, I talk about a case called Howe versus Cooper Vision, and that's at 83 CCC 1466. And in that case, applicant had a stipulation back for a 2002 injury, 2002, had a stipulations. She had a 2016 non-industrial motor vehicle accident, which rendered her largely incapacitated. And because defendant never provided evidence that the treatment needed for the auto accident wasn't somehow linked to the original claim, we had to provide the treatment and the disability benefit, not the PD, but the disability accommodations like wheelchair, home health care, for a 2002 injury that was much less severe. Once the petition to reopen is filed, it opens Pandora's box. We want to try and make sure we nail that shut if we're going to go forward. We want to make sure that all issues are addressed, and the only way to do that is to get a separate and distinct agreement, either via compromise and release, or via stipulations with request for award, or via trial. And remember, just because we might do a separate stip, if we're still within 5 years, they can file another petition to reopen. So timing is of all importance. We want to make sure that once we get this settled as best we can, It is done. Let's keep going here.
We have one more, and then I'll probably wait till the end just for timing, but I'll ask this one last question. We can save the rest for the end. Would a judge set a trial without medicals? I see often that they continue a hearing to, in quotes, develop the medical record.
There is no legal basis for the judge to develop the record, and there's case law saying this, to develop the record for petitions to reopen. There is no legal basis. That doesn't mean they're not going to do that, but there's no legal basis to do that. And my theory is when you get down to that first hearing and the applicant attorney cries that they have no medical evidence, I'm going to cry back and say, then why did you file a petition to reopen? If there's no evidence that it exists, why did you file it? Was that a frivolous filing for which you can be sanctioned? Is, oh, I want to protect my client's interests. So go, well, so do I. Let's go to trial on it. Or at a minimum, let's go back to the QME. Let's get the evidence now. So I believe that pushing hard on these will get you a more favorable outcome. I believe that letting them sit is just waiting for a time bomb to go off. Now, going back to the question as to reducing disability, the Labor Code 5804 provides that we can file a petition to reopen to reduce compensation. Now, this must be filed within 5 years of the date of injury, and it must be filed within 30 days of a petition to reopen. Now, I will tell you that in my career, I have never seen one of these granted, never one time. But what I have seen is exactly the situation from the question asked earlier about the medical evidence comes back and indicates less disability than before. And if we have not filed this petition, the board has no jurisdiction to award reduced compensation. I'll say that again. If we have not filed a petition to reduce, the board has no jurisdiction to award the applicant any reduced compensation, even if supported by the medical evidence. So what I've started doing is whenever I see a petition to reopen come in, I want to get that petition to reduce filed as quickly as possible. Just simply saying, as does the petition to reopen, hey, we're saying there's additional disability. I'm going to come back and say, hey, I'm saying there's reduced disability. So at least I have that argument. I have not waived that option should we go to trial. Now, I will say again, I have never seen one of these granted, but it certainly gives us something to argue with applicant attorney and applicant if the evidence does justify a reduced award. Maybe then they'll consider a compromise and release. Maybe then they'll consider a more beneficial settlement. I give you a little bit more facts about the petition to reduce here. Feel free to read through it. I give you my takeaways, and I'm going to go over some of these very quickly. You want to make sure you send your appropriate benefit notice letters with Reynolds language. You want to make sure we can cut off jurisdiction in any way that's legally appropriate. Under 5405, there are 3 options giving them 1 year to file a application. Treatment is one of those. If we provide treatment 20 years out, they can file an application within 1 year of that treatment. Board's original jurisdiction, once the application is filed, it exists forever. Unless we get an award or order via compromise and release or settlement, it continues to go. I will let you review the rest of these on your own once you get the presentation. If you learn nothing today, what I want you to learn is that prompt litigation of these issues is vital to minimize our outgoing costs. Fight it. Now I will go on to the questions page.
And I do see, will these slides be shared via email? And maybe Diane can help me out with this. I do believe it's attached to this webinar under handouts. So hopefully you guys can download it there.
Yes, the handouts are attached to this webinar. It is under handouts. They're great. They're great handouts. Did a great job, Jim and team. It's always great to have information that people can utilize and keep for the future. Logan, I want to thank you so much for asking the questions in the back. Were there any additional questions? We do have a minute or two. Okay, I don't think that Logan's still on.
Oh,
but,
I'm here. I'm here.
Were there any additional questions?
Oh, I'm sorry. I thought you meant to the crowd. I am not seeing any left. Does anyone else have any questions? You can type them up and I can read them right now.
It's very nice to see how many people did ask questions.
Yeah.
We do a lot of these webinars and we get very few questions. And so it's great to see this particular audience is so engaged.
I appreciate the questions you guys. Through? Seeing a lot of thank yous and that Jim rocks.
Yes, Jim does. Diana, I totally agree with you. It was a great presentation. I love his style. So Logan, I want to thank you very much for being the voice in the back and asking questions. Jim, thank you so much for participating. We do love having you as part of our 12 CEUs Christmas. We do have 2 more coming up on Friday. So if you have not registered for those yet, please go to macropro.com and sign up for them. One of them is the acute rehab that we had to reschedule, so that is going to be there. And the other one is conducting a good faith investigation, the first 90 days of a claim. So that is an important topic as well. All right, everybody, until the next time, we will see you later and happy holidays. Bye-bye now.
Thank you. Bye.
Thank you, everybody.